Atlanta Press Club Debates 2008, the race for Georgia Court of Appeals, is brought to you from Georgia Public Broadcasting. Good afternoon. I'm Helen Neal, the noon news anchor at WGCL, and welcome to our continuing series of Georgia primary election campaign debates. Today's debate is organized by the Atlanta Press Club. Now, let's meet the candidates facing one another in the election for Georgia Court of Appeals. They are in alphabetical order: Tamala L. Adkins, a family law attorney; Sarah Doyle, who is a partner with Holland & Knight; Bruce M. Edenfield, who has been in private practice for 30 years; Christopher J. McFadden, who is a founder and past chair of the appellate practice section of the State Bar of Georgia; Perry J. McGuire, who is a partner at Taylor, Bush, Slipikoff & Duma, a business and corporate law firm; Michael Meyer von Bremen, a lawyer by profession, who has been a state senator from the 12th District since 1998; and Mike Sheffield, a criminal defense attorney from Lawrenceville, Georgia. So those are the candidates. Here is the format for today's debate. In the first round, each candidate will answer one question. 60 seconds will be allotted for the answer, and there are no rebuttals in this first round. In the second round, the candidates will question one another. And then in the third round, our panelists will continue the questioning. At the end of the question and answer period, each candidate will make a 30-second closing statement. Now, let's meet our panel of prominent Georgia journalists selected by the Atlanta Press Club. They are Wandy Lawson, the co-anchor of GPB's Lawmakers; Allie Palmer, a writer for the Fulton County Daily Report; and Jake Armstrong, a reporter from Morris News Service. In this round, the order of candidates to be questioned has been randomly selected. The first question from Wandy Lawson goes to Christopher McFadden.
Mr. McFadden, you have concentrated almost exclusively for over 2 decades on appellate cases. I'm wondering if you can speak to perhaps some of the challenges that might be serving on the court, considering your lack of trial experience.
Well, I don't have a complete lack of trial experience. I've handled a small handful of trials to verdict in front of a jury, and I have fairly extensive experience taking appointed cases in the juvenile court up until the last very few years handling evidentiary matters. But my practice as an appellate lawyer has entailed reviewing cases in the way that the appellate courts review them. I get cases as a cold record, which is the way the appellate court gets them, as a cold record, and I study the transcripts of what happened at trial on that cold record. So the experience I have is well suited to handling the work of the Court of Appeals and the experience of a wide variety of appellate cases, and discussing those cases with the lawyers who tried them gives me an ample and broad perspective for handling appellate cases, and it is a perspective that does not exist in the Court of Appeals in the same way that I have it, and would be very valuable for that court.
Mike Sheffield has the next question now from Allie Palmer.
Mr. Sheffield, you have not been shy about stating your positions on controversial issues like abortion, gay marriage, school prayer, and capital punishment. Given that these issues seldom arise at the Court of Appeals, why should voters care about your stances on these matters?
Well, I think it's important for voters, especially in judicial races, to know something about the background and the beliefs of the people that are running in the race. Up until recently, candidates for judicial races weren't able or weren't allowed to express their opinion about issues that the general public might find important. I think that particularly in light of the fact that these issues don't come before the Court of Appeals, that it's perfectly fine for me to talk about them because I won't have to be ruling on those issues. And I think it just gives the voters an opportunity to know something about who they're voting for. I mean, if this was a presidential race or a U.S. Senate race, a state Senate race, the voters would want to know everything they could find out about the candidates. I don't think it should be any different at all in a judicial race. And the U.S. Supreme Court has said that we are allowed to do that, and I think it's important for the voters to know where we stand on these issues.
Now it is Michael Meyer von Bremen's turn for a question from Jake Armstrong.
Mr. Meyer von Bremen, much is made from judges legislating from the bench, being an attorney and a lawmaker. What examples of that have you seen, and how would you prevent that if elected?
Well, I can't cite any specific examples of judges legislating from the bench at this time. However, I have seen the importance of following the rule of law, and I pledge to do that. The rule of law provides for order and predictability for our citizens. It also provides for patterns of behavior that the citizens will follow, not only the citizens, but the lawyers who have to go before the appellate bench, the lawyers who have to provide advice, to their clients as to which way the case may go. If you don't have order and predictability, if you don't follow the rule of law, if you legislate from the bench instead of serving as a judge following the rule of law, then you toss out predictability. You create a rule that says the only thing predictable about our Court of Appeals is it's unpredictable, and we don't want that. We want the citizens of our state to have some guideline as to what that rule of law will be.
Tamala Adkins, your question comes from Nwandi Lawson.
I'm wondering how you feel that your practice of family law has prepared you to serve the appellate court and how you would overcome your lack of appellate experience.
I've represented over 1,500 families and children in the state of Georgia. They are underrepresented in the Court of Appeals currently with the judges and the composition. I would give those people a voice. They deserve a voice. They are in the worst cases of their life. They are victims of child abuse, victims of domestic abuse, and those citizens in Georgia have a right to be represented. My experience in that uniquely qualifies me to sit on the Court of Appeals.
Bruce Enfield, your question comes from Allie Palmer.
Even after your time with the State Attorney General's office, you have continued to handle cases for the state as a special assistant attorney general. Why should voters feel confident that you will not be biased in favor of the state and its lawyers?
Well, first of all, of the cases that I've handled, that's only been about 30% of my practice to start with. Number two, I've also had conflict cases that I've represented individual state employees against the state of Georgia when they were a party in the same lawsuit as a state agency would be involved in. My experience as Assistant Attorney General, though, is a privilege. Less than 1% of all the lawyers in Georgia have the opportunity to represent state agencies from the governor's office all the way down. I've been entrusted over 34 years with some of the biggest cases and some of the most important cases that one could be entrusted with by the state of Georgia and the taxpayers. It's been a great learning experience for me. I've had complex commercial litigation that I've handled for the state, but I can be independent, and I would be independent, and I've shown that throughout my career.
Now it is Jake Armstrong's turn for a question, which goes to Sarah Doyle.
You're the youngest candidate running for the court, and you also have fewer years experience than any of your opponents. Is that all a matter of qualifications in your...
How do I feel about that?
Yeah, is that...
Basically, I would say that of the candidates, I am the youngest. I will be 41 on January the 2nd of this coming year, having practiced for 15 years, which is just 1 year less than Ms. Adkins has. So in the scheme of things, I don't believe that the years of experience make a lot of difference as much as what you've done in those years. I started off at a small firm where I began handling virtually every type of substantive legal issue on the civil side that is heard by the Court of Appeals. I have handled workers' compensation matters, those on-the-job injuries. I have represented individuals and defendants in car wreck litigation. I have worked on employment matters, contract disputes, eminent domain, negligent construction, you name it. The types of issues that are heard by the Court of Appeals are the things that I have tried those cases and handled those appeals. I believe that one of the other candidates has done a study, and in the Court of Appeals since those records, there are only 2 others who have more experience in the Court of Appeals than I do, so I do not see that as a hindrance at all.
And finally, we're back to Nwandi Lawson for a question to Perry McGuire.
In that the majority of your experience comes from the corporate arena and very little within the actual courtroom system, what do you think that you bring to the Court of Appeals?
Well, thank you. Thank you for having us today. I believe that my experience is the broadest of anyone in this panel of candidates, having 2 decades of a very diverse law practice, including 8 years as in-house counsel for one of Georgia's most beloved companies, Chick-fil-A, where I had the opportunity to touch very many areas of law, everything from complex litigation, complex business transactions, labor and employment issues, even having the opportunity to work with Truett Cathy and his WinShape Foundation within the juvenile court system and dealing with parental rights issues and juvenile issues. On top of that, I started my practice in commercial real estate, and I've practiced in residential real estate. So all of those things are overseen, and the Court of Appeals handles all of those controversies. So I think that having real-life, hands-on experience in a very diverse set of disciplines will add great value to my participation on the court.
That concludes round 1 of questions. In the second round, the candidates will have an opportunity to ask one question of an opponent of his or her choice. Please limit those questions to 15 seconds. 45 seconds will be allowed for the answers, and the questioner then has 30 seconds for rebuttal. The order of questions has been determined by random drawing. So candidates, please indicate to whom the question is addressed. The first question will be asked by Perry McGuire.
Thank you. This goes to Tamala. Tamala, you told a newspaper that you had never been sued by a client or other entity before, and yet when the news story came out, they found out that you had in fact been sued 3 times. Isn't that a question of honesty?
That is absolutely untrue. I revealed in my questionnaire to the Fulton Daily Report that I had sued and been sued by different litigants under business situations. I've had a small business for 16 years, and I absolutely disclosed that. The one client that sued me for a fee dispute because he hired me to represent him in his divorce, got back together for his wife, and wanted approximately $1,500 back in a retainer. It had nothing to do with my ability. He, in fact, when he did get divorced, came back and asked me to represent him, and I would not because of his litigious nature. He then went on to get a divorce and was put in jail for not paying attorney's fees for that divorce and put in jail for not paying child support.
You have 30 seconds for rebuttal.
Well, I have not seen the Fulton County Daily Report print a retraction or a correction to their story. And I believe it does come down to the question of the incredible amount of trust that are placed in judges to be honest, ethical, and forthright. And I believe it does come down to a matter of character when a person answers a questionnaire falsely.
Christopher McFadden now has the chance to ask a question of one of your opponents.
Perry, in 2002, the Supreme Court of the United States struck down the canons of judicial ethics which constrained what judicial candidates can say. You have said in some of these forums that you would not be governed by your predispositions, but you've also said that refusing to state one's predispositions is a cop-out. In your letter to the Georgia Committee for Ethical Judicial Campaigns, you said that it would be inevitable that predispositions would come out. Would you reconcile those?
I don't remember saying that predispositions come out would be inevitable. As a matter of fact, that is contrary to what I believe. I believe that it is important for the people of the state to know the candidates for this office. That is why the Supreme Court struck down those laws of restraint when it comes to judicial elections. And so it's important for people to know who I am. They need to know that I have taken positions in the past. They need to know that I am a conservative former state senator. I was a 2006 Republican nominee for Attorney General. I can't hide for that, nor do I choose to. Will that impact the way that I judge cases? Absolutely will not.
You have 30 seconds for rebuttal.
The Supreme Court of the United States has also held that there is a constitutional right under free speech to burn the flag. That doesn't mean you should do it. Now, obviously, we're not talking about something as extreme as that, but I think it's critical that candidates for judicial office be mindful of their predispositions and skeptical of them, and not run in any way suggesting that their predispositions would control their decisions.
Bruce Edenfield will ask the next question.
This question goes to Ms. Atkinson. In a recent poll of the active members of the State Bar of Georgia, 56% of the attorneys responding who said that they had sufficient information to express an opinion on your qualifications for this office responded that you were not qualified. In light of the fact that more than half of the lawyers who said they know you do not believe you are qualified, how can you seriously say you are the most qualified candidate in this race?
Mr. Edenfield, this poll was sent out to all the lawyers in the state of Georgia. About 10% of them responded. I have does not surprise me at all that those who don't know my work, which are many of them because I've represented individuals and families in Georgia, not lawyers, did not vote that they knew me. This is a popularity contest with the bar, Mr. Edenfield. We would have been surprised if you had not won. Your dad was a federal judge. Your uncle is a current judge. Your uncle is the state bar president of the agency that sent this questionnaire out. They don't know my work.
You have 30 seconds to respond.
Well, over 3,143 lawyers responded. over 50%, 56.57% of those who responded said they knew the qualifications of Ms. Atkins. And as a result of that, over 50% said she was not qualified. It's not a popularity contest because these are lawyers who are responding with information where they said they had sufficient information to know that candidate and were able to cast a vote.
Thank you. The questioning continues now with Mike Sheffield.
I'd like to ask Michael a question. Sure. Michael, we do get a lot of questionnaires sent to us in the campaign. Do you have a policy on whether you'll respond to them? What are your feelings about them?
The questionnaires, first, I was one of 4 candidates who signed the pledge or agreement on judicial ethical campaigns, and part of that was to not only follow the canons of the Judicial Qualifications Commission, but follow the commentary that was within those canons. And I signed that pledge, and part of the commentary talks about the questionnaires and not taking sides or prejudging issues. And I feel that to answer some of these questionnaires that are sent out would cause that. Now, there are some questionnaires that are asking about your background and maybe some experience. That's a different thing. But when they're asking you about issues and asking you to prejudge those issues, I'm going to stick by those canons and the commentary that's in those canons and follow those. And I think that's important to show neutrality, independence, and impartiality for a judge.
You have 30 seconds to respond if you'd like.
Well, I'm one of the candidates that didn't sign the pledge, and I didn't sign it because I think it's important for the candidates to let the voters know something about their background, something about their worldview. And I just think it's important now that we're able to speak out, now that the Supreme Court, the U.S. Supreme Court has given us that opportunity, that we let the voters know a little more about us than we were able to before, so they can judge us like they do in other races.
Story Doyle gets the next question.
My question is for Chris McFadden, and I believe that the people watching this need to know a little bit more about the court. And so I would ask you, what do you think is the most serious issue that's facing the Court of Appeals today?
I think the most serious issue facing the Court of Appeals today is its caseload. It is arguably the busiest appellate court in the country, handles 3 times the number of cases that are recommended by the American Bar Association, the National Center for State Courts. And that creates internal pressure on the court. It undermines the ideal of an appellate court, which is vigorous discussion among the judges of each case. Caseload creates a hydraulic pressure that puts more and more of the responsibility for each case on the individual judge assigned to the case, assigned primary responsibility for the case, and within that judge's chambers to the law clerk assigned to responsibility for initially drafting the opinion. So it's particularly important that a judge of the appellate court be familiar with the work of the appellate court, and my appellate experience gives me that preparation.
Would you like to respond?
Yes, I would add on to that I think recent budget cuts to the Court of Appeals is already negatively impacting what Mr. McFadden was saying about the already overburdened court. The Court of Appeals is one of the busiest in the country, hearing more than 2,500 direct appeals each year. My experience at Holland and Knight as a partner there, I think, makes me particularly suited for helping out, as I have worked with a team of people to lead a large caseload efficiently through the court system in a timely and efficient manner, and that's sorely needed on the court. Thank you.
Next question comes from Tamala Atkins.
Mr. McGuire, this is for you. Mr. McGuire, you've been a wealthy corporate attorney for your entire career. You've raised very little money in contributions from lawyers, and you have put $200,000 of your own personal wealth into your campaign. If you are elected, are you going to set a precedent that you have to buy your way onto the Court of Appeals?
We made a decision very early on in our campaign, after the first disclosures came out, that it looked like the amount of money raised by any candidate in this race was not going to be significant, considering that it was a statewide race. And that has borne out to be true. Our focus has been on developing our grassroots. That means reaching out to individual voters throughout the state to come on board with us, as they did in 2006 during my Attorney General's campaign. And we have done a very good job in reigniting our support from throughout the state. And that is why we have 4 congressmen who have endorsed our race, dozens of state leaders throughout the entire state, along with local elected officials and sheriffs. So we're proud of the organization we've built.
30 seconds to respond if you'd like.
I challenge the voters of Georgia to go to the Secretary of State website and see who's contributed to whose campaign. I've raised the most money since this race started on July 1st, 2008, the second most total. and that's from a broad base of support, including judges that I practice in front of, including trial lawyers, defense lawyers, prosecutors, criminal defense attorneys, and many, many of my clients who I've helped throughout the state.
Our final question in this round goes to Michael Meyer von Bremen.
Thank you. Mr. McFadden, you've handled a significant amount of cases on the appellate level. I think you've said more than all the other candidates combined. I think your website has a distinction saying that it's since 2000 when that information was available, if you can perhaps clarify. But I want to compliment you for that experience. However, I think also many of us have trial experience, and I want to ask you, wouldn't you agree that a blend of appellate and trial experience is a good value to have and carry to the Court of Appeals?
There are two questions there. There is a study on the web page that was done by my treasurer, Charles Cork, an attorney out of Macon, and he worked up a program that interrogated the Court of Appeals website. It counted open cases by docket numbers and counted lawyers associated with it, pulled them up and counted them, and that's how we come to the conclusion that I've had more experience in that court than the other 6 candidates in this race combined. I acknowledge that trial experience is a useful experience, but there is no one on the court who has the sort of experience that I have in terms of a wide variety of appellate experience over 20 years, having literally written the book on practicing in that court, having written a part of the Appellate Practice Act. That is an extremely valuable experience that does not exist on the court now.
You have 30 seconds to respond.
I again compliment Mr. McFadden for his wide background in the area of appellate practice. I've used his book myself. I do think that it's important to understand that going to the Court of Appeals has an in-the-trench value, where lawyers who have been in the trenches and on the front lines with these trial cases know what it's like to have objections, having to raise them at the last second, know the backgrounds of many, many cases, and I think that background that I have, trial experience and appellate experience, will serve well. Thank you.
Thank you. That concludes our second round of questioning. For our third round, we go to our panel of journalists. From this point until the closing statements, the panel members will ask questions of the candidate of his or her choice. Candidates will be allowed 45 seconds to respond. And again, as moderator, I'll determine if any opposing candidates will be given 30 seconds for rebuttal. We begin this round with a question from Allie Palmer from the Fulton County Daily Report.
Mr. McFadden, I want to follow up on the issue of caseload that Ms. Doyle brought up. As an appellate judge, you will have to manage a tremendous caseload working with several law clerks and court staff. You've been a solo practitioner most of your career. What sort of experience do you have managing people?
Well, I manage a small staff in my office, paralegal, and an accounting manager, and I have from time to time worked with other lawyers, having them assist me in writing briefs, although I've done relatively little of that. In addition, as a practitioner, an appellate practitioner, I sometimes have consulting cases where I'm helping other lawyers write their appellate briefs, and that's very similar to the responsibility of an appellate judge in working with staff attorneys to whom work has been delegated. But, you know, the critical thing is that there are some excellent staff, there's an excellent corps of staff attorneys up there. I think they may have more average experience than the judges themselves. And the critical thing for an appellate judge is to be able to do the judge's job, not tell the excellent experienced staff attorneys who come with the job how to do their job.
Our next question comes from Jake Armstrong.
Mr. McGuire, since the Court of Appeals is one of the busiest in the nation, do you think that says anything about the rulings lower courts are handing down?
No, I don't think so at all. I think it's just a reflection of the amount of cases that we're seeing in our public. It's become more of a litigious society. We're seeing an increase in criminal prosecutions. All of those funnel up through the Court of Appeals. So I believe that it's just a function of where we're headed, and I believe that we are going to have to address that. And whether or not it is, there's been some pressure to increase the size of the court. I think it's time for us to start looking at how best to address the issue of volume.
Next question comes from Nwandi Lawson.
Ms. Atkins, I'm wondering, you just stated that you've raised more money than the other candidates in this particular race. Why do you think that that fact impacts your qualification to serve on the Court of Appeals?
I think most of my contributions have been, the list of contributions that I hope that the people of Georgia, the voters of Georgia, will go to the Secretary of State and review are from a broad base of attorneys that either know me or have worked with me. It's not based on any kind of agency poll. It's where they have opened their checkbook and written those. That means that they know my work, they know what kind of lawyer I am, and they know what I would do on the Court of Appeals, or they would not contribute to my campaign. I think that's very important.
Next question comes from Allie Palmer.
I'd like to follow up on that topic with Ms. Atkins. Each of the candidates is receiving monetary contributions from lawyers. Why should voters feel comfortable that this will not influence your decision-making should these lawyers appear before you?
I think it's a very important question, and I think that all of us have people that we're friends with. I'm sure Ms. Doyle, she has a big firm, and she's going to know a lot more lawyers than I probably know. There are going to be people that come in front of me, and I'm going to have to make sure that if I feel any kind of personal relationship with that attorney, that I would recuse myself. What is important in my particular race is the broad base of attorney support that I have in my campaign.
Next question comes from Jake Armstrong.
Mr. Enfield, I'd ask you to name one mistake you've made in your legal career, and what would you do differently now?
Well, one mistake may have been that I did not, in terms of my criminal background experience, I've tried several criminal cases. The majority of my practice has been civil litigation, civil trial litigation all over the state of Georgia. About 2% of my practice, Mr. Armstrong, has been involving a criminal practice. And of course, the Court of Appeals, about 42 or 43% of the cases that come up to the Court of Appeals deal with criminal matters. But I feel pretty confident that I have the capabilities of handling those type cases. I have the ability to discern the law in that area from my broad range of experience.
Our next questioner is Nwandi Lawson.
Mr. Sheffield, you have said that the judicial races should be comparable to other political races and that voters should know about the viewpoints of those running. I'm wondering, how can you assure voters of your impartiality as you would serve on a court?
Well, I think it's equally important, even though we can and I think should express our opinion on issues, that obviously if I'm elected and the people that are judges now have to be impartial. And I can just assure the voters that I would set aside my personal beliefs, because that's what a judge has to do. I mean, let's face it, all the judges that are sitting now have personal opinions about these controversial issues, but they're able to set them aside and render decisions fairly and impartially just based on the law. That's what the judges are bound by. And in my 35 years of practice, I've handle lots of trials and lots of appeals, and so I believe that I have a good background in the law and can follow the law.
Next question from Allie Palmer.
This question is for Senator Meyer von Bremen. We hope that voters will get information about the candidates from programs like this, but I worry that only our families are going to watch this debate. And electing judges, is electing judges the best selection system, and why or why not?
Well, I certainly think that, of course, in Georgia we have a blend of electing the judges. In this situation where Judge Ruffin has decided not to seek re-election, so his term will expire and it creates an open seat. And then we have a method of appointing the judges where somebody retires early and a governor appoints the judge. And I think right now it's the best system we've got available to us to go through this elections process. I will say that I have noted many citizens who are not aware of this campaign. Even a lawyer in Middle Georgia, when I handed him a pamphlet, he said, "I appreciate this, I enjoyed what you had to say, but I can't vote for you because I don't live in your district," and it's a statewide race. So I think it's important that somehow the press, like you're doing, gets the word out to the public that this is a statewide election and it is on their ballot.
Next question comes from Jake Armstrong.
Mr. McFadden, when voters head to the polls, they're likely to make their choices based on name recognition and not necessarily qualifications. What can be done to change that?
Well, it is up to the candidates to do the best they can to get the word out. It is up to the press to do the best it can to get the word out. There really isn't any other third person that you can point to. And we've done the best we can do in our campaign to get the word out, and I hope your periodicals and broadcast networks will do the same.
And Nwandi Lawson gets the next question.
Mr. McGuire, I'm wondering, since a lot of your career has focused on being an advocate for a company or in the case of voters at certain points, what examples do you have of how you make decisions that demonstrates your ability to be impartial?
Oh, absolutely. I think that having served as a state senator is a perfect example of where I proved that I was independent in many areas, whether it was dealing with criminal issues on the Special Judiciary Committee, making sure that we have a process that is fair as is intended by our founding fathers. I think that being in the corporate world where you have competing interests and making sure that you're doing what is right ultimately for the owners of the company, I think giving them good counsel shows that you have to be able to pull your personal views out of situations and be impartial.
Next question comes from Allie Palmer.
This question is from Ms. Doyle. In your campaign, you have emphasized not only your legal experience, but your life experience, in particular being a mother. Why should voters care about that sort of life experience in choosing an appeals court judge?
Well, I mean, this is not a competition for who's got the most appellate experience or who's tried the more cases or who's been in public service the longest. What the voting public needs to be looking at is who they think is going to be the best person to sit as a judge on the Court of Appeals. And I think it's important for them to know not only what my legal background has been, that I've handled all the substantive areas that the Court of Appeals hears, but that I am a wife and a mother, and I understand what the families and people who work and live here in Georgia go through every day, and that I'd bring that perspective to the court with me while making rulings. And, you know, that's part of who I am, and therefore I think that they should know that.
Next question comes from Jake Armstrong.
Mr. Sheffield, I'd like to ask you now, one mistake you've made in your legal career and what you do now differently.
Well, I wish I'd handled more civil cases, sort of like Bruce Enfield said. He hadn't had a whole lot of criminal experience. I wish that I had handled more civil cases. Most of my experience has been doing criminal law, first in the DeKalb County District Attorney's Office and then on the defense side, which I think is very valuable in this race because a large portion of the Court of Appeals caseload is criminal. But I would feel better if I had done more civil cases. But I think anybody on the panel probably doesn't have a perfect background of having done civil and criminal. And if elected, I would certainly get up to speed on the civil side.
And Wandy Lawson gets the next question.
Ms. Atkins, you mentioned earlier that you would like to serve on the court in a role to promote some of the issues around family law that you've served in throughout your career. How would your role shift? What changes do you see yourself making as a judge on the Court of Appeals versus an advocate for families?
For instance, this year the child support laws have changed, and I'm the only one of the candidates who's had extensive experience with child support. And those are very, very complicated changes in the law. They're very confusing. The Court of Appeals will be handling those child support issues in any post-divorce modification litigation where most of domestic relations go up to the Court of Appeals. I'm uniquely qualified to handle those issues. In domestic relations law, you handle a variety of different issues. You handle issues regarding children, their property, division of assets, and you get a wide variety of civil experience.
Next question comes from Allie Palmer.
This question goes to Mr. Edenfield, again on the topic of contributions from lawyers. Do you favor stricter rules for when judges may be required to recuse from cases because a lawyer or litigant in the case has given a certain threshold amount of money to a judge's campaign?
No, I don't. I think that this is a matter of integrity. Every candidate that runs for office is going to, and has to raise money to get the word out. That was one of the other questions that was asked earlier by this panel. How do you get the word out? And all of us are doing the best we can. I think it's been foreign to me to go. I've never been a candidate for a race of this nature, and going out and trying to solicit funds has been a challenge. But from a judge's standpoint, a judge who receives money from somebody who's supporting his candidacy, he's got to step back from that. It becomes a matter of integrity of that judge. Can he set aside any contribution? Just because somebody gave him a contribution doesn't mean that he's beholden to that particular person who gave him some kind of financial support.
Next question now comes from Jake Armstrong.
Mr. Meyer von Bremen, apart from experience, what other qualifications make for a good judge, and how can voters see those qualifications in you?
Well, I think a well-rounded background for a candidate for a judicial position is very critical. I've been married for 22 years to my wife, Peggy. We have 2 children, Meg and Wellesley. They are both in college, one at Georgia and one at Auburn. Hope I didn't lose any votes with any of those distinctions between the colleges. But in any event, I feel that having been a father and raised children and know what it's like to be in a family situation, being in Southwest Georgia where we have a general practice more than we do specialized practices like you see up in Atlanta has been very, very valuable to me. I think a well-rounded candidate who's involved in their community, and whether it's the Boy Scouts where I was an Eagle Scout to United Way to my church, I've done that, and I think that's important for voters to see.
Our next question comes from Nwandi Lawson.
And I'd like to ask you, Senator, what you would see as being some of the biggest challenges in switching from the role that you've held in the state legislature for many years, as well as being an attorney, to serving on the Court of Appeals.
Well, certainly it's going to be a change because now you are you're serving the law and not constituents. I've said many times in forums that judges do not represent constituents, they represent the law, and that is very, very important. However, I think even in the legislature while I was there, I often sought common ground. I often sought to look at the best result for the law, not because of partisanship, but because of what was important with the law that was being passed. And I think I can take that with me to the Court of Appeals and work with other judges when we have the panels and we have to make decisions about cases and try to work for what's best in the decision following the rule of law and following our Constitution. And I think that will serve well. Thank you.
Let's see what Ali Palmer has next.
This question is for Mr. McGuire. Your campaign today announced that it is running a radio ad that describes you as a pro-family conservative. How would that philosophy find its way into your judicial opinions on the court?
Well, I think that the judicial, of course, my role as a judge is not going to entail any constitutional questions at the Court of Appeals level. We know that the Court of Appeals does not handle any constitutional issues. I think that what I want people to know and what we're trying to convey is that I am like them. I've been married 22 years. I have 4 children. I am a cancer survivor. Feel like I have the life experiences that help me to relate to the everyday experiences of the citizens of this state. Along with that, I think that that makes me predictable, and I believe that's important in the role of a judge. But as far as any bias, I don't think it has any sort of bearing on the way that I will carry out my duties as a judge.
For our next question, we turn to Jake Armstrong.
Ms. Adkins, can you describe your judicial philosophy for us?
My judicial philosophy is that I would review a trial court level, a trial court transcript, and I would apply the law as written at that point. The law may change over the tenor of any of my seat on the Court of Appeals because parties may change. Law is made by parties, either Republican or Democrat. It is the job of a Court of Appeals judge to apply that law to the trial court decision and whether that judge made the correct ruling or not. So my judicial philosophy would be to apply the law to the facts of the particular case that would become in front of me.
Next question comes from Nwandi.
Ms. Doyle, I'm wondering if you can speak to some of your specific experience with your firm that would make you more qualified than the other candidates for this post.
With respect to my current firm at Holland & Knight, it is one of the largest law firms in the country. We have about 1,100 lawyers. There, I have had a broad legal experience handling class actions, complex litigation. At any given time, I am leading a team of attorneys, mainly associate attorneys, of about 5 or 6 on maybe 10 to 15 different large litigation matters. I am the person responsible for overseeing those, making the day-to-day decisions about how those cases are going to move forward, all the time giving guidance to the people below me who are working. On the Court of Appeals, you have a judge who has 3 staff attorneys who is working on a panel with other, in my world would be partners as the comparable example, to keep those cases going, get the decisions out. And I think that experience in the large law firm sets me apart.
Next question comes from Ali Palmer of the Fulton County Daily Report.
Mr. Sheffield, candidates for judicial office often talk about how they will be independent, fair, and impartial on the bench. Would you give us an example of something you've done prior to running for this office that shows your independence, how you went against popular opinion?
Well, for 15 years, I was a public defender in DeKalb County, and that's probably might go against the public opinion. You know, first I was in the district attorney's office there, then I was in the public defender's office. It's a hard job, handles a tremendous caseload, but we're not, typically in the courtroom, we're not always the most favorite person. I would probably say that about just being a criminal defense lawyer in general. So I think it's a hard job, but I think it's good because I have a good background in criminal cases, having served as both a prosecutor and a defense lawyer. So I think that gives me a great perspective on the court of having been able to see both sides.
Next question comes from Jake Armstrong.
Sir Edenfield, if your name was not on the ballot and you had to vote for one of your opponents, who would that be and why?
That's a good question. I don't know if I could say who I'd vote for. All of them, everybody in this race brings certain qualifications. Everybody has good attributes. Everybody has their background and their experience. What I try to do is focus on the positives of my experience. In fact, part of the thing that we've all agreed on, or at least 5 of the 7 agreed on, that we were not going to go negative in this race. I admire people who have public service, like Mr. Brennan and Mr. McGuire. I have 34 years of public service as Assistant Attorney General, trying cases all over the state. All of the lawyers, Chris has written a book. We've got lawyers who've done a lot of criminal work. When you look at it on balance, what's important here is that the public and the people who are voting in this race have an opportunity to discern what all the qualities are in all the candidates and then try and make the most informed decision.
For the next one, we turn to Nwandi Lawson.
And I'll ask you as well, Mr. Edenfield, what do you feel has been some of the greatest experience that you've gotten since you've been before the Court of Appeals so many times? What are some of the experiences that you bring from that would enable you to serve that court?
Well, obviously, I've written a lot of briefs. I've made a lot of oral arguments before that court, over 65 appeals that I have handled, both in the federal courts, the Supreme Court of Georgia, and the Court of Appeals. When you're up before the court, one of the things that you want to be able to do is talk about the material facts. Not all facts in a case are necessarily going to be relevant to the outcome of that case. So you want to, I think, one who has had the experience of being up there, and from a judge's perspective, a judge is looking for what is the material fact in this case is going to be controlling. And that's what discerns just an average lawyer coming up there who's not prepared, and one who really knows that record and knows what's important for the judges to know.
Next question comes from Allie Palmer.
This is for Senator Meyer von Bremen. For the last 10 years, you've represented the Albany area in the state Senate, even serving as the Democrats' minority leader for a couple of years. Why should Republicans feel comfortable voting for you?
Well, it is a nonpartisan race that we have here, where there's no Democrat, there's no Republican, there's no Libertarian. And I think, number one, the fact that I have over 50 of my former and current colleagues who have endorsed me, some of whom are Republicans, does show that I have been able to serve as an independent legislator from time to time. I have been trying to reach common ground on issues that are not partisan but are important for Georgians as a whole, and I think they've recognized that. I've been a lawyerizer in the legislature for years, where people come to me from both sides of the aisle and ask me to help them with their bills and help write their bills and help clarify gray areas in their legislation, and I feel that's a good attribute, and I think they recognize that I try to work across the aisles for the common good of people of Georgia.
Jake Armstrong of the Morris News Service.
Mr. McFadden, given the state's budget situation with a predicted $2 billion deficit and making that kind of unlikely to add staff to reduce caseload on the Court of Appeals, what else can be done to reduce caseload?
Well, there's nothing that can be done to reduce the caseload that's legitimate, other than a decision by the General Assembly to take away the right of direct appeal in more cases, give the court more categories of cases where it can decide whether or not to grant a full-blown appeal or just decide it by application. That's the only thing that can be done to reduce the caseload. The Court of Appeals cannot legitimately reduce its caseload. It has a responsibility to correctly decide all the cases that come before it. And the grim fact in terms of budget is that there is no fat on the Court of Appeals, as the chief judge of that court has said. When the last cut muscle, laying off 4 of the 6 central staff attorneys.
Next question comes from Nwandi Lawson of GPB's Lawmakers.
Mr. Sheffield, can you tell me, characterize for our viewers what your judicial philosophy is?
Well, I think I'm not sure judges should have a judicial philosophy. I mean, each case is completely different from any other case. I think all we can do is, and what the Court of Appeals is doing, of course, is reviewing the record below, usually from a trial in superior court, to determine if any errors were made. And for that reason, all that judges really are doing are looking to see if there's any errors. Both sides have submitted a brief outlining what they think the errors were, and we're just reviewing the record to see which party might be right. So I think it's important for judges not to have a judicial philosophy, but to keep an open mind and rule on the cases based on the law.
If we could, can we go down the line on that one? Because I think that's what a lot of people would like to get the answer to. We'll start down here with the A.
That's my question. I answered. I'll be glad to. Answer it again. The most important thing for a judicial candidate is to have trial level experience, so you can read the transcript and read between the lines of what happens, and then apply the law as it is right in front of you with those two litigants. Not a generalized personal opinion or a party opinion. It's what happens in the trial court, applying the law as written the day it comes in front of you.
Sarah Doyle?
As a practicing attorney, I do not currently have a judicial philosophy, but I believe that a judge should approach each case as if it is the only one in front of it, to read the law and apply that law to those facts. Not to in any way legislate from the bench, but to apply the law as it was written before it, and to do their best to issue decisions that are fair, reasonable, and consistent, so that the practitioners and the people who are parties in those cases will not only understand the rulings, but know what to rely on.
Bruce Enfield?
I agree with the last statement. The judge's position, and I'm not going to put, there's no label to put on my judicial philosophy. It is to follow the law, the rule of law. That's the glue that keeps our society together. And every case that comes up before that court ought to have a fair shake, on a fair playing field for all who come before it. And to sit there and try and label, if you say I'm a liberal or conservative and all that, that's really just trying to pander to the public, when in fact the judge must, on his own accord, step back from that and try and give a fair assessment following the law based on the facts of each case.
Christopher McFadden.
Well, I agree with all of that. If you look at what Justice Scalia and Justice Breyer and Judge Bork have written on the subject, they're all looking for the same thing, which is an objective, analytical way to step back from what they're doing and make sure that what they're doing is applying the law, not indulging their own predispositions and prejudgments. So a judge should not embrace a judicial philosophy as though it were a political ideology. That would be wrong. I would like to be described as a judicial minimalist, but again, that's just a descriptive thing, and it's just an assertion of one of the ideals of good judging, which is not to overreach in terms of what you cover in the decisions.
Perry McGuire.
I believe, I like what Chief Justice John Roberts said during his confirmation hearings, that we need to remember as judges that we are servants of the law and not the other way around, that judges are more like umpires, that we don't make the rules, we just apply them. And no one shows up to court just to watch, or no one shows up to a ball game to watch the umpires. And so I would characterize my philosophy as one of restraint, that I think we need to make sure that we are applying the law only to the facts before you.
Michael Meyer Van Bremen.
Thank you. It's repetitive of what the other candidates have said somewhat, but I think following the rule of law and the Constitution in a fair and impartial manner, every case, every time, is critical for a judicial philosophy, and that's what I would follow as a judge. You know, we go through these construction zones and see speed limits of 60 miles an hour. They are created for safety purposes. Some people may not like them. The judge may not like them. Does that mean the judge should create on their own legislation from the bench to say, however, if everybody else is doing 80, you too can go 80? No, I think you follow the rule of law every case, every time. Thank you.
Next question comes from Allie Palmer.
I'd like to ask Ms. Doyle the same question that I asked Mr. Sheffield. Could you give us an example of something you've done prior to running for this office that shows your independence, a time that you went against popular opinion?
I'm not sure that there is a situation that I could point to that would say that I went against popular opinion. I have been nothing more than just a hard-working attorney, sort of kept to my own to my own self in my office, minding my own business, I guess is the way I would describe it, so that I have not had occasion to either try to go against or for popular opinion on any particular matter. I think it's that sort of lack of participation in any political or outside interest group process that makes me particularly suited for the court and is the position of a judge, someone who can be independent because I don't have any of those issues that are influencing me in any way.
Final question in this round comes from Jake Armstrong.
Ms. McGuire, I'm wondering, you also received a 43% approval rating in the state bar poll. How much weight do you give to that?
Well, I didn't participate in it, along with about 90% of my fellow lawyers. As a matter of fact, I think 400 of the 27,000 lawyers in this state rated me as not qualified. And I don't know 400 lawyers in the state, and they don't know me. So I put very little stock in it, and I say, God help us if lawyers start electing the judges in this state.
Our time for questions has now expired, so it's time for closing statements from each of our candidates in the election for Georgia Court of Appeals. Each candidate will have 30 seconds, and the order of the closing statements was randomly determined before the broadcast. The first statement will come from Tamil Adkins.
I could have worked for any of these big firms. I was top 5% of my law school when I graduated in 1992. I chose to represent individuals, families, and children in this state. That's what I chose to do. It's one of the toughest areas of law. Excuse me. It's not one of the most lucrative areas of law as some of the other candidates have chosen, but I chose to represent the people of Georgia. I think that the children, the families deserve a voice on the Court of Appeals. It's a logical continuation of my career to go under the Court of Appeals and protect those people.
Next, Perry McGuire makes his closing statement.
First of all, thank you for the opportunity to be here today. We are very proud of the support that we have gotten throughout the state of people who want a common sense, family-oriented judge on the Court of Appeals, someone who brings a diverse background, 2 decades of practice in very practical areas of the law, all of which are under the jurisdiction of the Court of Appeals. I only promise that I will work hard every day to be worthy of the trust that you instill in me.
Our next statement continues with Christopher McFadden.
I have done a variety of things that I'm proud of in my life. I'm proud that the Supreme Court of Georgia once appointed me to act for it as a special master, that the members of the Atlanta Bar Association have elected me an officer in line to be its president. I am married to a beautiful and brilliant woman who is a full professor of biology, and we have the most delightful 3-year-old son in the history of Western civilization. I've served my church for 20 years as a lay minister. But the argument for my candidacy is a depth and breadth of experience with the Court of Appeals of Georgia as a practitioner, as an author of the book on the subject, as a founder of the Appellate Practice Section, and having written a part of the Appellate Practice Act.
Thank you. Next one comes from Mike Sheffield.
I would certainly appreciate your vote for the Court of Appeals. I thank all the viewers for their interest in the Court of Appeals race. I'm honored to run with such a fine group of fellow candidates. I believe that I have a unique blend of trial experience and an appellate experience, which makes me a good choice in this race. And I would very much appreciate the opportunity to serve you on the Court of Appeals.
Michael Meyer von Bremen is next.
Thank you. I'm Michael Meyer von Bremen, and I will be the longest name you're going to see on your ballot for the Georgia Court of Appeals. I've got more than 25 years of courtroom and appellate practice, and combined with that is the fact that I've served as a state senator representing 8 counties in southwest Georgia for over 10 years, where I chaired the ethics and the special judiciary committees. I've had a direct role in writing and passing many laws throughout our state, and I think this combination of courtroom practice and legislative service provides a well-rounded background, critical and conducive to upholding the Constitution and rule of law in a fair and impartial manner for the citizens of Georgia. I'm proud to have over 50 of my co-legislators endorse me. Thank you very much for this today.
Thank you. Our next closing statement comes from Bruce Enfield.
Justice Holmes, one of our nation's leading jurists, said that the life of the law has not been logic, it's been experience. I have 35 years of trial experience and appellate experience. I've tried cases all over the state of Georgia. I'm the most experienced trial lawyer in this field of candidates. I believe a judge should not be beholden to any particular political party, to any special interest group, or to any individual. I believe a judge should possess unyielding integrity so as to foster appreciation for the judicial system. I think a judge ought to bring common sense to the court. I have all of those qualities. And I'm Bruce Edenfield, and I'm asking for your vote on November the 4th. Thank you.
And our final statement comes from Sarah Doyle.
I'm Sarah Doyle, and I'm running for this position because I believe that the state of Georgia deserves to have the very best attorneys sitting as judges on their court, those that are smart, hardworking, and independent. I graduated in the top of my class at Mercer Law School. As a practitioner, I have been recognized as one of Georgia's legal elite, a super lawyer, and as one of the top 50 female attorneys in the state. I have experience handling virtually every one of the substantive legal issues handled by the Court of Appeals. I have tried those cases and handled appeals. I am a wife and a mother, and I understand what the people of Georgia, what their concerns are, and I will bring that perspective to the court. Thank you.
Thank you. And that concludes our debate. Our thanks to the candidates and also to our panel of distinguished journalists selected by the Atlanta Press Club. We would like to thank the Atlanta Press Club itself for arranging today's debate. For more information about the Atlanta Press Club and the candidates and future debates, go to atlantapressclub.org. This debate will be archived at that website. I'm Helen Neal. Thank you for joining us for Debates 2008.
This program was funded in part by a grant from the late Tom Watson Brown and by supporters of Georgia Public Broadcasting. Thank you.